to order. This is the House Judiciary Non-Civil Committee. We're here to continue our consideration of House Bill 722. We had to press pause on consideration of the bill last week due to some conflicts that the author had, which is fine. The subcommittees were able to go ahead and do their due diligence on other bills, but we're going to go ahead and pivot back to consideration on 722. This will be a hearing only today. Members, the purpose of the hearing today is for the author to go through the bill section by section or part by part, whatever is going to logistically work better for him, and take questions and answers from members of the committee. We'll just see how the flow goes. I don't know if you want to go through the whole bill and then go from there, or maybe do it section by section, or at least topic by topic, and then go from there. We'll just see how that occurs organically, like we always do, and engage in a good dialogue. So with that, let me recognize Representative Peake. The substitute that you have, and let me just make sure I'm identifying it correctly. We're working from LC 296883S as in Sam. Is that right? Okay. Members of the committee, this is a substitute that the author has proposed. This is not a committee substitute. I just want to make sure that's clear, and that's the substitute that that Representative Peake will be working from. So with that, let me see if I can get this to work. Let's see if it does work.
Testing 1, 2. Yep. Eat at Cheddar's every meal. That work?
Is the light on there?
Yep. Yeah. Sounds like I'm hearing it back here.
Okay. Is the volume okay in the back? Okay.
Testing 1, 2. Testing 1, 2, 3. Hello. Testing 1, 2.
Okay. We're good. Representative Peake.
Thank you, Mr. Chairman, members of the committee. Glad to be here before you again. One, let me shout out to Jill Travis, who has helped tremendously on this bill, trying to come up with a piece of legislation that both is efficient and works, and I think that's what we've done. But if I can, I want to take just one moment before we get to the nuts and bolts of the bill to remind everyone of why this bill and this legislation is so important. I received an email this week from a young lady I've never met before, and she basically said, I wish there was a way for me to test the CBD-THC ratio of the oil that I've made for my son who has Tourette's syndrome. She's physically making it on her own in her home. Since we've had some early success and have seen a reduction in his tics from his Tourette's and an improvement in his demeanor, this leads me to believe that whatever is in there is a good combination for him. And here's where just hang in there with me for a second. This is the mom writing. This is the first time in over 4 years that I've had hope that my son, who I think we got a picture of him up there. I don't know if we can get it. Okay. The first time in 4 years that I've had hope that my son can possibly live something that resembles a normal life. If this continues to work and I can also find him something from a dispensary that works, then it will change his life. It will change the life of our entire family as we all hurt for him. How soon might this bill pass and go into effect? Folks, those are emails I get almost daily, and reminds us of why we're doing that. 16-year-old boy. And then one other quick comment, and I think this will be relevant. I had someone fellow by the name of Alex send me this email this week. He said, I see that you have to have final stages of cancer to qualify. I need this to stop the cancer before I have to undergo chemotherapy and other harsh treatments. For the record, it's very discouraging that these oils and treatments are considered illegal by our state. Now, this wasn't just some random fella that sent me this email. He's the son-in-law of one of our colleagues, Paul Battles, son-in-law. Sent me this message this week begging us to make changes so that we could have access here in Georgia. I asked Paul for his permission to tell that story. That's young Gage, that fell in the first story. Thanks. You can take that off now. So I say all this just to remind us that we have learned about the challenges that citizens face, the civil disobedience that some of them have been willing to take, and we can fix this. We can come up with a solution for our citizens here in Georgia with this bill in HB 722, and so that's what I hope we can do. Okay, let's dig into the meat of the bill. And Mr. Chairman, I'll go section by section if you want me to.
Yeah, whatever works for you. Let me just tell you, we have a hard stop at 3:30 for another meeting that starts here. I think I'm going to have you go until about 3 o'clock-ish or so. We have a couple of folks who have traveled who had been scheduled for last week, but then we had our schedule change. They've traveled from out of the metro, so I want to hear from them for 20 minutes to half an hour, maybe not that much, and then we'll go from there. We'll more than likely have another hearing on the bill. I know originally we had thought about we wanted to have a pro day, and then we wanted to have a con day, and then we had our schedule problem.
Right.
So I think we should have some time for representatives of the other side to go ahead and to say what they have to say.
Okay.
And then the committee will take it back and we'll figure out what's possible.
Okay.
So I just want to make sure that logistics on that were clear and turn it back over to you. Thank you.
That sounds good. I'll go section by section. I'll make a brief comment about each section, and then you can ask questions, or Mr. Chairman, I'll go at your discretion. If you have questions, you're welcome to ask me. We are on this bill, we're affecting 4 different titles: 16, the criminal section, Title 31, the health section, 26, the pharmacy section, and 21, the tort section. The bill is going to be known as Haley's Hope Act Part 2. Section 2, on page 2, we make a statement that we are clear that this is moving forward to somewhat address some of what Representative Setzler talked about last week. That this is clear that this is for medicinal purposes only, and not in any way, shape, or form moving toward a position of legalization for non-medical use here in our state. Section 3, I want to give you a couple of dates that you need to keep in mind: July 1st, 2016, and July 1st, 2017. If the bill goes into effect and is signed into law from July 1, 2016 to July 1 of 2017, we will have a need to keep the low THC oil, the current law, in place, because we have several family members that are using medical cannabis oil now to treat their diagnosis. So in Section 3, we basically keep the low THC oil language in place to provide for protection for existing citizens who are already on the registry, and also for the clinical trials that are being conducted as well until July 1 of 2017. And that's basically page 2 and 3, and that's just the basic protections that are already in current law. Section 4, we deal, starting on page 4, we deal with protections for the manufacturers. If in July 1 of 2016 it goes into place until July 1 of 2017, when manufacturers will have the ability to dispense medical cannabis legally in the state, we will have manufacturers that will be in possession of marijuana, and they need to have protections during that transition time until they are actually dispensing the oil. And so that's what Section 4 is basically protection for manufacturers from July 1 of 2016 to July 1 of 2017. I address you to line 142, that's through 147, that's actually penalties for employees that violate this law during this time, again, consistent with what we did in HB 1, which is tougher penalties for someone that violates this law than it is in current law for possession of marijuana as well, too. Section 5, starting line 153, is the protection for patients starting on July 1 of 2017. And this is where we come up with the definitions as well for cannabis device and manufacturer, and marijuana and medical cannabis and solid substance. We start in line 169 through 177 of what the possession requirements are. It can't weigh more than, no one can have in their possession more than a certain amount of grams of solid substance or more than 20 ounces of a liquid substance. It cannot be, in line 173, it cannot be dried leaves or plant matter. That's line 174, it's a labeled pharmaceutical container. And 175, that person has to be registered with the Department of Public Health. So we put the possession requirements in there starting in lines 171. So.
Can I break in and just ask you, just to expand on a theme having to do with the solid substance and what we're talking about? Because to this minute we've been talking about oil in the context of the bill of HB 1 last year. Mm-hmm. Now we're talking in the context of a solid substance. I understand it cannot be the dried leaves or plant matter as relates to 173.
That's correct.
I think we need a little more understanding collectively on what are we really talking about. What is that substance? What, as opposed to the oil that we know of, what can or cannot be done with it, and what, et cetera.
what the attempt was to allow a delivery method other than oil for someone who maybe could only take it in a capsule or tablet type form. And so that was the intent. There's protection that it's not dried leaf matter. It's already inherent in the law. So it would be the substance of the marijuana plant ground down to what would be allowed in a capsule. So that may not be as good an answer as you're looking
Is the
for.
ground down versions, I mean, can that be abused other than what, obviously we know about the oil, we know it, we're comfortable.
Well,
So what can be done or not done with this substance that we're talking about, because it's a completely different track than what we've been on.
Well, we can we do put in there that you can't have more than a certain amount of grams per at any given time, or that it goes into a felony type position. So again, if you're looking for a THC limit on that, or I'm not sure exactly what you're.
No, I mean with the oil, it was the type of thing that the attraction of it was, of course, from a public safety standpoint and enforcement standpoint, was that you tried to get high with that oil, you're going to be spending a lot of time in the bathroom.
Right,
Good.
Right.
So to get away from the abuse factor, when you're talking about the solid substance, what can be done with that substance, if anything? Is it the same thing as the oil, the same kind of result if somebody tries to smoke that substance or tries to do things that I don't even know about?
Well, it wouldn't be in a dry leafy matter, so I know that.
Right.
And I may not have a good answer for you that. I may need to do a little homework on that to address that specific question.
Okay. I mean, what happens if that dry substance, if somebody consumes it, what's the effect of that?
Yeah. Well.
Okay.
Yep. It is on line 134. Yeah, or 134 or 135 too. Yep.
Right, and I guess
I understand what you're trying to get to.
Yeah, I mean, it's just what is it that's in the capsule, and then what can be done with that from orally or not.
Yeah.
I mean, it could be just like the oil in terms of its the end product. Someone could try to abuse it and make themselves just incredibly ill.
Right.
What's the difference between the oil, as far as that goes, and anything that's in these capsules?
And I will do my best to try and get an answer to find that.
Thank you.
And Mr. Chairman, the members of the committee, obviously this is not a perfect bill yet, and I'm looking forward to input from you guys to help perfect it. And if there are issues that need to be addressed, I'm clearly open to address them in that particular situation. Okay, we talked about the possession requirements from 171 to 74. We go down below at the bottom of page 6 where there's the punishment for violations of this as well too. Again, consistent with what we did in HB 1, that the punishment for violation of this law is even greater than regular possession of marijuana. And then we provide a remedy in lines 208 to 211. If you don't have your proper identification card, there's no criminal conviction if you can produce it at some later point as well too. And then starting in lines 213, we talk about where you cannot possess medical cannabis and how you cannot possess medical cannabis, and it's to address starting in line in 234. Not allowed to be possessed on a bus, or on lines 236 on the grounds of a school, or lines 237 the grounds of a child care learning center, to make sure that it's not allowed where there are children around. It does. I do want to make sure it's clear in line 233, though, we make the emphatic statement that it is unlawful to smoke medical cannabis, that it's clear that smoking is prohibited in this bill. And then in lines 241, 242, we provide some protections for parents, just a clear statement that the administration of medical cannabis to a child, as long as it's within the guidelines of this bill, is not considered a violation. Okay, and then we get into Section 6 on page 8, where we get into Title 31 of the Health Code, and that's where we start on line 252 of the definitions, the new definitions that will be added for this legislation, including attending physician, a cannabis device, a designated caregiver, a disqualifying felony offense. And then in lines 269, where we address, which has got a lot of attention, intractable pain, a definition that we've gotten some input from physicians and physician associations on this as well too. And then in 281 we clearly define what medical cannabis is now. In 283 a medical cannabis manufacturer, and then in lines 288 we get into the 18 qualifying medical conditions. We had 8 in original HB1. We've added 10 more. Most of those have been added through what's consistent and what's done in other states, as well as through feedback from different constituents as well too. It should be noted that in line 299, where intractable pain is listed as one of the qualifying conditions, that it requires that it has been diagnosed by another physician in addition to the attending physician. So it does require 2 physicians for someone to meet the standard of intractable pain. New definition in the code. Intractable pain, stringent, more stringent than what is in the current code for chronic pain at this point. And that's, you see the rest of the conditions all the way through line 319. It should be noted from the original bill we took out glaucoma. That was a request at the request of Ophthalmology Association. We did add peripheral neuropathy, which is consistent with in many other states that have full medical marijuana programs. Lines 320 and 327 states again that there's no requirement for this to be covered by insurance. And then we start in lines 329 on page 10, the licensure application for those who are interested in applying for a license to become a manufacturer of medical cannabis. Consistent with the original bill, it's a minimum of 2, a maximum of 6, determined by December 1st of 2016. In lines 341, we put what the conditions for licensure are, that they begin and be ready to go by July 1 of 2017. And then in lines 346, we put what the qualifications to be considered for licensure are by DPH. And you'll bear with me in 348 through...
Mr. Peake,
yep.
Let me interrupt. I apologize.
Okay.
That seems like a good topical break point because we've come,
Okay.
right before we
Yep.
get into the licensing of the manufacturer, we have this block of policy on the additional qualifying conditions, and then, of course, the substance issue and the qualifying conditions before we get to the licensing. So I'm wondering, members of the committee, and there may not be, if this would be a good time just to naturally have questions on that first block before we get into the manufacturer, if that's all right with you.
Sure.
Are there questions from members of the committee, I guess, on the first 10 pages before we get to line 320? Before we get to line 329, which is where we get into the licensure on the manufacturer. Mr. Hightower.
Thank you for bringing this bill to us. My question goes towards the employee or agent of the manufacturer. Looking through here, it says it shall be lawful for an employee or agent of a manufacturer to possess or have in his control marijuana, medical cannabis, or cannabis device. And when we go back and we look at marijuana, shall mean all parts of the plant, whether growing or not, the seed. So essentially they could have anything in their possession connected to a marijuana plant. It does say that if that employee or agent is found to dispense this through distribution, sale, that they could be charged a felony. However, that's all it says. I may be missing it because I haven't worked all the way through this, but it doesn't give any parameters that employee or agent is acting within the scope of their employment. So
we may address that. I may ask Jill. I think we addressed that later. Is that right, Ms. Travis?
Have we not gotten there yet? Because the way I read it now, it just says that if you're an employee of a manufacturer, you can have this, and it doesn't give any parameters no scope on that.
It does at lines 139 and 141. You have to have your identification with you.
Right, but just because you don't have an identification on you doesn't mean you're acting within the scope of your employment. So I mean, I think we'd need to have something there to say they're acting with. Oh.
Yeah. I understand your point of somebody that just happens to be on the street corner with marijuana in their pocket and having it an identification on them, and that's not necessarily from the manufacturer. It's a separate crime. That's probably not an issue that we've addressed as of yet.
Okay. That was one we may just want to look at.
Okay, yeah, sure will. That's the point.
Mr. Pack.
Thank you, Mr. Chair. Representative Peake, on line 115 to 119, you're striking some language in there, and I think that we voted in last year.
Mm-hmm.
And by striking it, and walk me through this, that section allowed an employer to maintain their zero tolerance policy. So in other words, they go and test for THC, obviously, and they fail. By repealing it, are you saying that the employer can no longer use that as a basis?
If you'll hang on with me, we address that in a later piece of the language where we try and address the employer-employee relationship. We're trying to come up with that middle ground of a person that is legitimately using medical cannabis for a legitimate purpose under state law, and is an employee, but may fail a drug test because they've got metabolites in their system because they're taking medical cannabis. How do we provide some protection for that employee, but also for the employer to make sure that that's not abused? And so we've attempted to address that in language later in the bill. If we could, if it's okay to answer that at that time.
Sure.
Okay.
Mr. Setzler.
Thank you, Mr. Chairman. And I know we'll have an opportunity to talk about these kind of things, as we move forward in the process. I would ask Representative Peake to speak to a couple things that I saw. I wanted to ask about one thing that was brought, and I don't think it was really adequately addressed in the last hearing. Is just wasn't time. We have limited time, as you well know, and there were people that needed to be heard last time. So we, tried to use discretion in our getting into the details. But as you look at the, I'm going to find the line number that's on. If you look at the definition of intractable pain, I would alert members of the committee to take a look at this. It's line 269 to 276. The initial bill that was filed had a definition of intractable pain that changed in the last substitute, and that the change is the addition of a clause here on line 270. And I think it's a very important public policy thing to identify. I would love to hear your thoughts on it. When you look at the way that intractable pain definition works with the ors and the ands, intractable pain means a continuous pain state in which the cause of pain cannot be removed or otherwise treated with the consent of the patient. And then the ands follow on. But the way that functions, if you look at this sentence, if the cause of pain can be removed using other pain remedies, but those options are not consented to by the patient, then a patient that wanted to be able to have medical cannabis as their selection, as their choice, could look at, okay, these 6 options that a physician gives me that could solve my pain. I don't consent to 1, I don't consent to 2, I don't consent to 3, down to 6. And then if someone chose to not consent to any of the alternatives, they could work their way down to medical cannabis as being the only solution. Now, this clause was not in the bill that was dropped, that was initially filed. This is a new addition. It was this clause, or otherwise treated with consent of the patient. This was added in the last substitute, and it's here in this substitute. The way that functions is by someone not choosing to give consent to other pain-solving medications, one could get themselves to a place where the only thing they get is cannabis. This is an ability to choose cannabis as a solution for pain per se.
Yep.
And I want people to understand that. That's what this does.
And I'll be more glad to address that.
Please.
In some respects, Representative Setzler, that ought to be a choice that's left to the patient. We choose now which narcotics or drugs we want based on recommendations from a physician. Some of those particular narcotics or drugs may cause side effects that, while it causes and diminishes the pain, it may cause other side effects that diminish the quality of life for an individual. And so it does leave that decision with the patient to be able to say, hey, this is not a treatment that is, while it diminishes my pain, it diminishes my quality of life as well too. And so why shouldn't I have the option to something else as well?
And Mr. Chairman, I raise that into the author. When you look at across the country, the circumstances in which medical cannabis is prescribed, the average nationwide, if you look at the states, depending on how you look at the statistics, is in the 92-93% range of the prescriptions for, quote, medical marijuana, medical cannabis, is for a pain-based problem.
That is correct. Yes.
Now, we've been talking about other circumstances, and I think Representative Peake's brought some folks here that have stories that I think will be compelling to this committee. But let's be very clear, and I wanted to share this with you and certainly members of the committee. What we're talking about here is a bill where 6 to 7% of this bill is about the pains, is about the medical circumstances that people have brought before us, and 90 to 95% of this bill is about people who are having this, who are getting marijuana for pain under a set of circumstances in which there could be other options for their pain, but they have the sole discretion to not consent to any other option, thereby getting marijuana. If I can articulate any pain, and we recognize nationally this is overwhelmingly the case, this is a medical marijuana bill for pain, in fact. 95% of this, 90 to 95% of this bill is going to be for people who can articulate pain and can deny any other cure and have marijuana as their drug of choice. That's what this does, in fact. That's why we talk about words on the page versus about the people who had some very serious conditions that I think this committee would be friendly to. I highlight this clause to you because I've got concerns about that, and I think members of the committee need to understand that this is a bill that is fundamentally different than what was perhaps proposed in the other series of conditions that were brought before us in the committee.
Ms. Travis, you got any input? I mean, I know we worked hard on trying to get this thing tight and strict. Is that your correct interpretation?
Which is a policy call about
Yeah.
pain, but I don't recall that there's been a substantial change.
Yeah, hit you, Mike.
It's
In fact, Representative Sutch, I'll believe you, but I don't know that we changed this from the original definition that was in HB.
that one clause, Ms. Travis,
22.
or otherwise treated with consent of the patient. That consent element is I mean, in my opinion, this is artfully written. This is written, you could teach a law school class on this, but that clause was the only change in this definition from the original filed bill to what we have here.
Well, let me just caution members that, I mean, it ultimately will be a policy call. I mean, if the author, let's keep it to an interrogatory if we can, if there's a specific policy call. And if it is, and it may just be an agree to disagree, that's fine. But I do want to make sure that we keep the wheels turning on specific questions. But I mean, that is a threshold policy call, as the council
And
notes.
I'm willing to work with the committee on trying to address any concern that you have. So,
Okay. Mr. Gravely.
Thank you, Mr. Chairman. Just, and thank you, Mr. Peake, for the work you've done on this. Section 2, I believe it was Section 2 or 3, where it talked about there being no repeal of the current Haley's Hope Act in regard to those patients who are currently receiving low THC or CBD-only oil. Just to be clear, whether or not this bill passes, and let's say in the event it does pass, which I am hopeful, those who are getting low THC or CBD oil will be able to continue getting that oil even if it's from another state, correct? There would be no prohibition of them possessing that in this state.
that is correct, and I'll defer to my expert lawyer because we went round and round about this to make sure that parents who now currently under current law are obtaining it from another state by whatever means and have legal possession of it here in Georgia would continue to have that right and ability after July 1 of 2017 as well, but the definition of changes to medical cannabis, which is allowed under Georgia law, and the low THC oil is inherent that it would be included in that definition as well too. So is that? I'll defer because we had lengthy discussions to make sure those families would still be protected to be able to get it from somewhere else.
One more, if I may. And that's what the committee, this committee, the process is so that we can go through, we can deliberate and debate these types of issues, the wording in this bill. Is there a sneak attack at work here that we're trying to put something in to pull one over on Georgia citizens or law enforcement, or are we doing something? Are we using words and crafting words so that if this bill passes, we can say, "Aha, we got you." You know, we allowed the Spicolis of the world to benefit. Is that what we're trying to do here, or are we trying to? Are we trying to get medicine to legitimate medicine to people as medical science advances, as the technology, and we hear from folks, be it Children's or other reputable universities and research institutes, are we trying to do something that would allow citizens of this state access to a medicine that is proving successful, that is a lab-tested, safe medicine in a delivery system while we're trying to stay within the parameters of the law? Isn't that what we're trying to do?
That is, Representative Gravely. You hit the nail on the head. I mean, there are 23 states that have full medical marijuana legislation where citizens have the ability to be able to purchase medical marijuana in their state. There are 16 states like us who have low THC oil that allow just possession only. And each of those 16 states has encountered the same problem that we have, that our citizens who we say can legally possess cannabis, medical cannabis, for medicinal purposes, can't get it. They have to break the law, commit civil disobedience to obtain it from somewhere else. And so all we're doing with this bill is solving that problem. I have no intent to move toward legalization of marijuana for recreational purposes. I have no reason whatsoever to go there. And we've done our best with the advice of expert legal counsel to make sure that we're not trying to pull one over anybody. All we want is medicine for those that truly do have debilitating illness, and allow them to be able to have access to a safe product, legal product here in Georgia.
Thank you, Mr. Chairman.
Mr. Trammell, is that you?
It is.
All right.
Thank you to the author. And I think you started to touch on the question I'm about to ask, but is there a state that is doing something, set aside the conditions for the moment, but just the delivery mechanism? Is there a state doing something akin to the substitute, or is this new ground because it's somewhere between the low THC oil and whole leaf legalization?
Well, there is this transition that we would make from this low THC oil to legal access to medical cannabis has been done in 23 other states. So there's a model out there. We're following the Minnesota model, which is a very limited licensee, limited number of conditions, no smoking allowed. So yes, we're moving toward what Minnesota has done and implemented over the last 18 months in their state. Utah is currently right now in the same process of what we're doing. In fact, they passed legislation out of a committee in Utah for basically similar to our legislation. And so I think most of the 16 low THC oil states are just seeing, hey, we passed something that gives them possession, but they can't get it. And so yes, I think most folks are transitioning to that next phase of medical access to medical cannabis. Yeah.
Mr. Hightower.
I want to say I don't think that you're ever trying to get something over on us or get something over on the
I would never do that to an
Georgia.
astute group of lawyers like you guys as well too. So.
And I say that because in this process, when we do this, as Chairman Setzler said, our job is to look at these things from a mindset of we want to make sure they're right. We want to make sure that people understand what we're saying. Not that I think anyone would ever have that intent. I know you well enough to know that you would never have that intent. But some of these questions need to be drawn out so that there is full disclosure to everyone out there. One of the things that I'm having trouble with is a little bit with what Chairman Golick pointed out to you earlier, and I really want to, if we can't do it today, I really got to figure out this solid substance issue.
Okay.
And the reason for that is if we look at the bill on its face and we look at what we're defining marijuana as, and it's essentially the full plant, right? But then we come back and we say that we're going to allow less than 40 grams of solid substance, and then the very next says it is not dried leaves or plant matter. I'm assuming if I'd ask you that the reason we're doing this is to allow people to have access to parts of this plant, either an oil extract or whatever the case may be. But if the only two ways they can get it, which is through, from what I'm seeing here, either 40 grams of a solid substance or less than 20 fluid ounces of a liquid substance, correct?
That's correct.
All right. But then the very next thing is no dried leaves or plant matter. That we're saying two different things. I mean, if it's, unless I'm missing it, but if you look up the definition of matter, it's something physical. It's left from spirit world, so to speak, and it's now a physical thing. There's matter there. So if it's no plant matter, how are we getting it? So how you see what I'm saying? It kind of loses me
do.
there.
And if I had a botanist or a chemist here, they could probably explain to me better than what I'm clearly failing at, of what's inside that capsule. It's a processed extract of the plant. It's not the plant itself, and so, but I need to do a better job.
But if it's if it's an extract of the plant, so there's some portion of the plant in there. I know I'm just playing on words here, but we need to make sure we get it right. We don't need to say it is not dried leaves or plant matter, because if there's, and I'm not sure how they do the extract, but I'm assuming there's some portion of this plant in this stuff, or either we wouldn't have to be doing this.
Well, the cannabinoids are what's extracted from the plant, and that's what the CBD or the THC or the THCA or whatever the particular cannabinoid is, what is extracted from that plant, what is put in the oil that is then given to the individual. What I'm not having a good explanation for is what is actually inside that capsule, and
Okay.
and we need to do that, and we'll have a better explanation of that.
Yes.
At some
Thank you.
point. Yep.
Mr. Setzler.
Thank you, Mr. Chairman. I wanted to speak to Representative Hightower's thing, and I think to Representative Peake's point, the THC wax or hash oil or whatever the street name may be, I'm sure there's many of them. My research has shown that you're talking about it's sort of a resinous, waxy substance that's a 80 to 90% THC. The research I've done shows that you've got a market value of about $60 to $80 a gram. I think the more purified stuff's maybe $80 a gram, so 28 grams per ounce. You're talking between $2,000 and $2,500 an ounce for that wax. So 40 grams would be $3,200 worth of product, but it's a very high. It's basically the plant that they bubble a substance through it to extract out all the pure THC, and then that's evaporated off. You've got that wax that distills. That's the solid product we're talking about, and you can use a very small amount to accomplish the purposes we're talking about. But it's a pretty easy thing to physically deal with. But it's not a plant form or dried leaves. It is that solid distilled.
Yeah, and Mr. Chairman. There's an expert on this that could not be here today. I actually was going to have him sitting with me because I just anticipate some of these questions, and I'll make sure he's here for our next hearing. Maybe we can explain that a little better as well, too.
And I would ask, Mr. Chairman, to the author, one last question for his intention. On line 182, just from again, it's a policy question, but I wanted to, for clarity, you've got this bill that allows the possession of this medical cannabis product as defined in paragraph 1 of the subsection. But if you're in possession outside of that paragraph, which means you've got it but you don't have the proper permit and so forth, line 182 does make it a misdemeanor to not to possess this. So in essence, we're talking about possession of the high THC oil, not the hash oil, whatever we want to call it, or the product that's made legal, if you're in possession of it outside of the bounds of this bill, meaning you have more or you don't have the proper prescription, it's a misdemeanor.
I don't know that that's correct. I mean, we have provisions elsewhere that make it clear that if you have more than 40 grams, that it is.
Notwithstanding any provision, again, line 181, possession of without complying with paragraph 1 of the subsection shall be punished as a misdemeanor. So paragraph 1 is you can have this kind, can't have leaves, you can have up to 40 grams. These are really the provisions in which possession is made legal in the bill.
But if I'll take you to lines 196 through 199, where there is, if you have an aggregate weight of 40 or more or 20 or more ounces, then with intent to distribute it is guilty of a felony. So I mean, I may have to defer to Ms. Travis of the distinction between those two.
The setup is the same as low THC. It's exactly the same as the low THC oil. So that you have meet all the conditions and look at lines 40, 39 through 51. You'll see the exact same setup. It's just mirroring that language.
So the effect of that is again, as I'm reading on lines 181 and 182, you've got any person who possesses or has in control medical cannabis weight less than 40 grams without complying with paragraph 1.
Which is right above it.
Right, is a misdemeanor. So if you don't have the prescription, as I read it, it looks like on 182 it makes it a misdemeanor. I'm not clear on how that interacts with 199. And I just think that's an important policy point we need to understand.
I can tell you the intent was felony violation if you have more than a certain amount. So we'll go back.
So if you have under that amount, but you don't have the proper authorization, felony?
That's right. Or if you don't have your registration card, maybe if you don't.
It's the same as the low THC oil. If you have the under the limit amount, but you don't have everything, all your ducks in a row, it's a misdemeanor. But if you have over the amount, then it's a felony.
That's correct. So from a policy perspective, if I don't have authorization under this bill to have medical cannabis, I'm just a person that just has it. And as long as I maintain under 40 grams of it, as long as I have under $3,200 of it, if I have $1,200 of it, it's a misdemeanor. I have no authorization, I have no prescription, I have no nothing. But I have it. I'm in possession of it, it's a misdemeanor. If I decide to have more than 40 grams of it, then it's a felony.
Well, and I think that's consistent. Well, I asked some of the prosecutors on this, that 28 ounces is the benchmark for a misdemeanor to felony for possession of marijuana now. And I'm willing to move that back from 40 to 28 ounces, from 40 grams to 28 grams if we need to make it consistent.
Let me ask. I think Mr. Hightower may have some perspective on that. Then I want to get Mr. Reeves, who I think has his button pushed, and then we need to let Mr. Peake move on. We'll have another opportunity.
I think that's where I would assume that's where you were going with that. Right now we have a misdemeanor level of possession of marijuana now, and then we have a felony level. And I'm assuming that your thoughts on this, and you can correct me if I'm wrong, but that if you have underneath a certain amount, you are mirroring what current criminal law is. Very close. But what you're telling us is that right now, if the 40 grams is higher than what the current misdemeanor level is of possession, you'd be willing to make those mirror each other exactly.
Let me tell you where we were going with it. We were trying to, under this law, we'll get into it in a little bit, you can have a 30-day supply. Let's say a 30-day supply is 6 or 7 grams of a solid substance. Really, that's what we're dealing with here. We've already addressed the 20 ounces. We've kind of come up with that in the HB1 of a liquid substance, a solid substance. So if you got a 30-day supply, but you needed to come in a week before because you're going out of town for a period of time, and you needed to have maybe one or 2 months worth supply with you on your possession, we need to make sure we were below that threshold. Now, if you got 6 months worth of supply, you may well ask a question of what are you really doing with it. And so that was really the intent of kind of trying to come up with a number. 28 would probably satisfy that and make it consistent with. And so I'm completely fine with that.
Okay.
Mr. Reeves.
Thank you, Mr. Chairman. Representative Peake, this may not be a fair question because I know we've just gone through 10 pages, and so if going through the rest of the bill will clear this up, then please let me know. But kind of from a 30,000-foot perspective, at least in these first 10 pages that we've gone through, what are the significant changes? I know that some of the wording is different and some of the structure of the bill is different, but by and large, it feels like it does the same thing that the bill that we discussed a few weeks ago. And so can you kind of pinpoint 3 or 4 significant or major differences or maybe concessions if getting from where we were a few weeks ago to this, if you've made some concessions, can you kind of draw those out and kind of help us see where the difference is between where we started and today?
Yeah, the biggest thing we did is we added the criminal element. I think, Ms. Travis, that's probably something. We added the criminal element to the bill to make sure there were penalties there for violation. We removed the medical cannabis task force. We'll get that in a little bit because it seemed to be redundant and seemed to be duplicative effort. We removed the medical composite board from being in the bill and gave all authority to the Department of Public Health to work with the medical composite board and physicians. Yeah, we dealt with pharmacies a little bit just to kind of clear that up a little bit, make sure that they could actually be able to have their hands on medical cannabis without being in violation of their code section. So there really was more efficiency in the bill, not so much some policy shifts, if you will. Some of those we'll address, too, here in a minute.
Let me ask you to continue.
Okay. All right. You have to help me where we are. Over 50.
We're on page 10. We're starting the block on line 329 on the manufacturing piece.
The licensure application. Okay. Starting line 29, this paragraph deals with licensure application. That change is consistent with what we had in the original bill, minimum of 2, maximum of 6, and those are to be determined by the Public Health by December 1 of 2016. Line 341, this licensee is required to start by July 1 of 2017. We hit the qualifications that DPH will be required to look at, starting in lines 348, the technical expertise of the manufacturer, the qualifications of the employees, the long-term financial stability, the ability to provide appropriate security measures, ability to meet demand, and the ongoing assessment of fees and patients. These are qualifications that DPH will be required to examine. Then we get into line 360 with responsibilities of the Department of Public Health to provide information about dosage and composition. Again, we're putting a lot of responsibility on the Department of Public Health, giving them the authority. We wanted to streamline it by having it in one agency. Starting line 375, we get into the timeline for DPH. That by September 1, they would have to require to have rules and regulations. By November 1, they would have to advise as whether they've been able to license 2 manufacturers by that time. It gives them an extension if they're not able to do that. Again, with the entire goal trying to have access products sold here in Georgia legally by July 1 of 2017. 385 to 406 just gives DPH the right to examine licensees' records. And then we get into line 408. We start into several pages of the tracking requirements that each manufacturer would have to maintain a system that tracks marijuana as it goes through the process. And so for the next 2 pages on 12, 13, and 14, that's basically what we're doing there is putting the requirements that the manufacturer would have to have from a tracking standpoint. Then we get to line 473 where we begin to discuss the requirements of the registry. Now we have a low THC oil registry that's already in place. It'll be replaced with what we're going to call the medical cannabis patient registry. And this is in 473 to 479 is the requirements of the Department of Public Health for physicians. And this is where we took out Representative Reeves, the medical composite board, and put the responsibility on the Department of Public Health. That's all. The next page on line 15 is a procedure rules and procedures and rules that DPH would have on coming up with the forms that attending physicians would have to have to license someone. And then we hit in lines 507, we now have, as of the latest count, 545 patients that are currently on the low THC oil registry. What we would do is on June 30 of 2016, those with a current card would automatically be registered to the new medical cannabis registry. And so that's how we take care of those existing card holders. And then we start on lines 520 where we come up with a patient application for the registry. And this just goes to the nuts and bolts of what would have to be on the application for a patient to apply for the registry. We hit in lines 536 that they require the patient to submit a new registration every 2 years. They would have to, in lines 539, a disclosure form would have to be filled out by a patient. In lines 548, that we have to have a waiver form by the patient. All of this is consistent with what the current low THC oil registry requires as well too. And then in lines 5, starting in lines 552, it's the registry card process of what they have to, information they have to provide to be able to be on the registry. And then in lines, and that's through the rest of the page, on lines 584, we hit the conditions for that a patient has to have to remain on the registry. Lines 589, we get into a designated caregiver. There may be situations where a particular patient is an adult, but because of their condition or disability, they're unable to self-administer, and so therefore we create a opportunity for a designated caregiver. There can only be one. A designated caregiver can only have one person they're administering it to. And then in lines 600, the requirements of the attending physician, what they would have to do, that they would have to certify that the patient has a qualifying medical condition, that whether the patient is unable to self-administer. In line 610, they provide information to the department as needed. 620, they provide notification from the department and to participate in the registry reporting. They agreed to do that. We now have 212 doctors that are participating in the registry as the latest current count. And then in line 630, we make it very clear in line 630, there's no obligation for any physician to participate in the registry whatsoever. If a physician just doesn't believe in it, doesn't think it's the right thing, they don't have to participate in it. Then we get into line 636 where the requirements of the licensee. I know I went through those 10 pages very quick, Mr. Chairman. If that was mostly dealing with the registry for physicians and patients. Now we're going to move into the requirements of the licensee. I'll keep going until you. Okay. And so we hit in line 636 what is required of the licensee, the minimum of 2, maximum of 6 licensees for cultivating and dispensing. And the way we've set it up is that a licensee can operate up to 4 distribution centers, and these distribution centers based in line 642 and 643 are going to have to be in geographic locations approved by the Department of Public Health, so that all of them are not in Atlanta, so that folks in South Georgia, North Georgia, East and West are not denied access because they can't reach one of the dispensaries. Licensee can only have 1 growing, processing, manufacturing facility. Only 1. And up to 4 dispensing facilities. Line 653, we start with the lab requirements that a licensed manufacturer is obligated and shall have to have a contract with a laboratory approved by the Department of Public Health for the purposes of testing medical cannabis for heavy metals, residue, pesticides, so forth. A linchpin of this legislation is that we cause our manufacturers to lab test everything that they are using. The licensee requirements continue on page 20. We hit in line 671, the license shall implement security requirements that are put in place by the Department of Public Health. Again, a key component that they have security measures in place for protection that the marijuana that is grown in the facility is not abused or potentially violated. We also state in line 675 that a licensed manufacturer shall not even have office space or rent office space or have any financial relationship with an attending physician, to make sure there's clearly not a conflict of interest from a physician's standpoint as well too. Line 679, they're subject to reasonable inspection by the department. Lines 687 through 692 talk about that a licensee is required to do a criminal background check for every employee that is employed by the licensee. Line 703, the manufacturer can't be within 1,000 feet of a public or private school. 707, they're required to comply with all rules and regulations related to signage and marketing. There was a flyer put on my desk, and many of y'all saw today, by a handful of organizations that are opposed to this legislation that said it allows dispensaries in Georgia. And it had a picture of some little shack that could have been down in Key West. It may be out in Denver. I don't know where it is, but it looked like a little shack in somebody's backyard of a dispensary. And I can tell you for a fact, Representative Gravely and I both visited the dispensaries there in Minnesota that we're modeling after. And you could not tell the difference between this and a drugstore. Is that not fair to say, Representative Gravely? And so the folks that were putting out information that put on your desk today, trying to convince you not to vote for this bill, do not have a grasp of the facts of what we're trying to put in this bill. Because the Department of Public Health will have complete control over how that signage and marketing is displayed. Also, line 710, there'll be an annual certified financial audits required. Continue to have the licensee requirements starting in 718. They must be able to provide an adequate supply. Line 721, it shall take all the processing shall be in an enclosed, video recorded, locked facility. And then we hit in line 723 where the licensee is required to have on staff a pharmacist who is, or their designee, be the only employees who are allowed to dispense the medical cannabis. Again, a key linchpin of this bill that a pharmacist is required to be at every dispensary and have a consultation with every patient before they access medical cannabis. Line 728 is the dispensing requirements to verify the individual is on the registry. They assign a tracking number to the medical cannabis. We continue with the dispensing requirements down through line 745, that it's properly packaged. Line 746 can only contain a maximum of 30-day supply of dosage, so somebody can't come in and just get 6 months supply. And then we start in line 759 with the registry information, what's required, who can access that registry information. Key part in line 764 that peace officers and prosecuting attorneys can access the registry for purposes of verifying whether an individual registration card is valid as well too. And then we get into some really boring stuff on 767, line 67, page 23, where we talk about that the commissioner and department staff are exclusion from any disciplinary actions from being involved with the distribution of medical cannabis. We also talk about the commissioner shall not be civilly liable or criminally liable. That line 778, the possession of a registry card shall not constitute probable cause for an individual. And then we start in line 784, certain protections. Representative Pack, we start hitting the employer-employee language in this particular section as well too. That an individual would have protections from being denied a rental facility or access to property because of being enrolled in the registry. We then talk about in line 788 that an employer shall not reject applicant based solely on the fact that they're enrolled in a registry. But it does not, in line 793, does not limit an employer's authority to prohibit an employee from possessing medical cannabis on property. We've tried to provide some protections in 796. An employee shall not have standing to bring a civil action against an employer based solely of being enrolled in registry. And then in 798, an employer applicant is required to undergo drug testing, may present his or her registry card as an opportunity to make sure that is relevant. And so we tried to address those employee-employer relationship. Again, we've been working with the business community, the chamber. I will continue to do that, continue to work with them to see if we can make sure we come up with legislation that does work in the real world. And then the last protection is for custody. The person cannot be denied custody just because they're based and enrolled in the registry. And we're down to last. I'll just go ahead and finish, Mr. Chairman, if it's all right. We're down to the last 2 pages, and there'll be in lines 805 to 812. It again clarifies that no attending physician can have a financial interest in a licensee. Lines 814 to line 824, we get into the patient fees, $200 on a biannual basis. We reduce that fee to $50 on a biannual basis if an individual is receiving Social Security disability or supplemental Social Security insurance. The license fees are a application fee of $20,000 and a biannual a renewal fee of $20,000, and then we emphatically state that the licensee may charge patients a reasonable fee for cost. Section 8 is where we go into the pharmacy code, where we make sure that pharmacists can have access to cannabis or marijuana by striking that language from the pharmacy code section. And then in lines 9, we deal with the torts chapter, making sure that healthcare institutions and healthcare providers are not in violation by adding definition for medical cannabis into that code section. And then section 10, the final section, it just goes into effect to show the dates that we're going to have in place. That some sections are effective until July 1, 2016, and then others effective July 1 of 2017. And that's the bill, Mr. Chairman.
Let me, Representative Peake, let me ask you a question. We've had this conversation about mail order. Take a giant step back. The introduction of the profit motive involving something that is a Schedule 1 controlled substance is of concern to people, and not unreasonably so. We've had a conversation about mail order. We know that we think we know that there has been mail order in the past, in the present, and assumedly in the future.
For the
to some degree. Combine that with the now fact that the federal spending bill, the omnibus bill that was passed and signed late last year, I think, while not legalizing anything, effectively curbs and or eliminates funding for enforcement against states that have some sort of medical cannabis program. I don't know the exact latitude of that. I don't know exactly what those parameters are, and we'll get educated about that. But if we know we have mail order, we have mail order for a certain degree now, and now we know through the omnibus spending bill that there's not going to be any federal enforcement. There wasn't before. Now it's just on the record there's not going to be enforcement because there's no funding for it. If we know that's the case, why would we not, I guess the question would be is, why introduce a new industry potentially as opposed to either A, waiting for mail order to go ahead and catch up with demand or to serve the demand, if assumedly that industry is nervous because of enforcement. Now that it's been defunded, so there is no enforcement effectively going forward. Will that, and I know you don't speak for them, obviously they speak for themselves, but wouldn't you think intuitively that that industry would ramp up somewhat? And if it's not going to ramp up, to go ahead and serve consumers and patients, more importantly, in Georgia, then what can we do to help that, as opposed to introducing the for-profit motive for an otherwise Schedule 1 substance? I mean, the controlled substance. That we're trying to. I'm asking you about the potential path of least resistance that still helps people. What's the motive? The motive is to help people.
Right.
That's my motive. That's your motive.
Right.
Is the mail order path a realistic one to get there now with the defunding of federal enforcement?
I'll answer it in a couple ways. There have still been, in fact, I wish I'd have brought where the DEA has raided a facility even in the last 3 or 4 months, even after the omnibus bill has been passed, because it's actually been, it was the second year it had been renewed to do that.
But was that in a state that had some sort of medical cannabis
it was
program? And again, I'm not
it was.
pretending to know the definition of program and how that fits in that parameter.
It was, and here's some of the problem. Each of you should have what's called the Cole Memorandum. You should have it in your packet. I think we had it.
No, we're familiar with it.
Yep. And it basically gives the guidelines that basically the federal government will take hands off even before it defunded DEA.
Right, and the omnibus bill essentially ratified, in heavy bold quotes, the Cole Memorandum because there's no enforcement funding.
In some respects, that is true.
Okay.
What has manufacturers concerned is that in the Cole Memorandum, one of the key, they gave about 8 components that said, hey, we're going to stay away from as long as you stay away from these 8 conditions. And one of the conditions was that you prevent diversion of marijuana from states where it is legal under state law to some form to other states. And so it, in effect, Cole Memorandum said, okay, well, we'll stay away from you, even though I know it's now been compounded with DEA non-funding. But one of the key linchpins was you're not shipping it to other states. You're not sending it to other states. And so that's what's got people nervous. And quite frankly, Mr. Chairman, at the end of the day, until Congress acts, there'll be a good bit of that confusion and risk.
But mail order is occurring now, isn't it?
It is for low THC oil product that is considered hemp, below 0.3% THC.
Okay.
Still significantly below even what our current law is. And so for someone, and many of the families that we know who needed a higher level of THC, even for their kids with seizures, that's allowed under Georgia law, they can't get that shipped. And the manufacturers are still too nervous because of the Cole Memorandum to ship it.
And the defunding aspect of the omnibus bill doesn't cure that?
It gives comfort, but it still does not provide absolute protection to these manufacturers who invested millions of dollars, who may all of a sudden have a DEA agent come in and say, well, you're shipping it. Sorry, we're shutting you down.
Okay.
Because it's in violation of the Cole Memorandum.
Shift gears. Sticking with the for-profit theme, what are the preclusions, if any, on looking at the issue from a nonprofit approach as opposed to a for-profit approach? I've had members come up to me and ask me about maybe the university system. If not the university system, if that would cause complications with their tax status for some reason,
Which it does.
then another nonprofit entity, whether buying through the state or not through the state, or perhaps just frankly through a state agency, just flat out state agency, maybe the ag department, maybe someplace else. I'm not suggesting that. It's merely an intuitively obvious possibility. What's the push? I mean, I understand the push on for-profit, but what are the preclusions on not-for-profit?
Okay, I'll address that in two ways, too.
Okay.
The 23 other states that have this, many of them, and including the 16 low THC, have tried to do it through a state agency or an institution, and they all run the same issue of they risk federal funding by being involved in a product that's still a Schedule I drug. That's always been the hurdle that no one in the entire country has been able to overcome at this point. So that's why that hadn't been a good viable option. It would be the simple solution, it seems like, but it hadn't been a viable option for us or any other state. To answer your second question, I'm not opposed to looking at a nonprofit model as one of the licensees. In fact, it's been done. I think we looked at. You should have in your packet the 23 states, their models as well too, and the 16 low THC. And I think there are a handful of states now of the 23 that do have that only allow nonprofit. And the fact of the matter is, the folks that I've chatted with, are investing a significant amount of money. They'd probably tell you it's nonprofit, at least until they get up and running for a while. But I'm not opposed
well, it's
to
a control issue.
Yeah.
I mean, it's a control issue. And the question
as
is,
far as what the demand is based on whether there's enough conditions to
well,
meet.
I mean, and nonprofit does not mean no money.
Right.
It means just nonprofit,
Right.
and how that entity is designed and controlled by whom or what would be the operative issue. But you say there are one or more states that actually do it through. Is it a nonprofit like a nonprofit what we think of just conventionally, or is it buying through government or some quasi type agency?
No, it's what you would traditionally call a nonprofit organization.
That's exclusively has an exclusive contract with the state, or
they are granted the licensees. They're granted the licenses to provide medical cannabis through a dispensary model.
Okay.
And so I'm not opposed to that, and I'm open to look at it. I think we get more.
I'm just trying to get educated on it.
Yeah, I think we get more potential players, if you will, on a profit motive, obviously,
Sure.
than we would. But I'm open to that and willing to have that discussion. Sure am.
Mr. Atwood. Oh, I'm sorry. Yeah.
Thank you, Mr. Chairman. I bring your attention to line 636 on the licensed manufacturers, and I just want to be sure, and I may have missed it. You may have already addressed it, and I apologize for not being here, but I had to be in two places at once, which is a little difficult. Is it possible for a licensed manufacturer to have more than one licensed manufacturer in a geographical area. I noticed down on 643 that the department will provide rules and regulation parameters for the geographical location of all distribution facilities. I'm just trying to wrap my brain around how this would actually work. Could there be more than one? I know they're limited to what they can do and how many distribution facilities they can have and that sort of thing. But can you have more than one licensed manufacturer under this law in a geographical area?
Well, here, let me go it the other way. Let's say there are only 2 licensees granted, and one of them is Alex Atwood Enterprises and one of them is Allen Peake Enterprises. Both of those entities can only have one facility that is designated for cultivation, processing, and production into the final product.
I see.
Each of those entities can have up to 4 dispensing locations that have to be geographically located across the state.
But there's not a limit on how many you can have in a certain area.
No, sir, there's not a limit.
Gotcha.
But it'll be up to DPH to make sure that the dispensaries are geographically.
I wanted to be sure I was reading that right. Thank you.
Yep.
Ms. Ballinger.
Thank you, Mr. Chairman. Is there a fiscal note for this? I noticed that the Department of there's going to be a lot of, it seems like a lot of, obviously, regulation and that sort of thing. So I was wondering how much it was going to cost.
Yep. Oh, I think there has been a fiscal note asked for, I believe, from your office.
There's been one requested. I wasn't aware that it actually had come in.
But here's what I can tell you. We had the folks in Minnesota, and we've modeled this bill after, tell us exactly what it cost you. And here's the very close numbers. It cost around $2 million to implement the program in its first year, meaning to get the software to integrate between the different agencies that were required to set up the infrastructure, $2 million. On a going-forward basis, the salaries on a going-forward basis have to administer the program is about $1 million. Now, we anticipate that if on a, let's say you had 100 patients being charged $100 a year, roughly, because $200 annually, that's $1 million of fees. That in some respects, the program on a going-forward basis should be self-sustaining. But there will be a need for some, and our guess is, in fact, I've made a request in the 2017 budget for approximately $2 million for the implementation of this bill.
Okay. Do we have any idea of how many, I know we're adding, this bill contemplates adding conditions, but do we have any idea of any kind of numbers as far as how many people would be on the registry?
Well, I mean, we have 545 with 8 medical conditions now, and we're looking to add 10. So, and that's without even having access here, be able to get it. So I would anticipate that we would have, I'm guessing, but I would imagine we'd have anywhere from the low thousands to 10,000 people who would potentially sign up for this registry. Minnesota, I think, is close to 1,000 people, and it's been in place for 7 months now. So.
Okay. All right. Thank you.
Ms. Kendrick.
Thank you, Mr. Chair. I have a question about lines 330 and 331, and this going back to licensure, which is, I think I asked you a similar question the last time you was here. But if it's a minimum of 2 and a maximum of 6 in-state manufacturers that are going to be licensed, what happens, or can you point to me where it talks about if you get over those 6? How are you going to decide who's going to get those licenses?
Well, there were a couple of reasons for limiting it to this. One, we heard from law enforcement they were concerned that we couldn't control it. So we said, okay, well, let's limit the number of facilities. And in Chairman Atwood's example, they would only have, let's say it was 2, they would only have 2 growing facilities in the entire state that they would even be able to have to worry about. And so that was why we limited it to a maximum of 6. If there's a greater demand and there's a need for more dispensaries, I guess that's something we as a legislative body would have to come back and address that, whether we want to add additional. The concern was we don't know what the demand is, and so why allow 20 licensees when some of them may go out of business if there's not enough demand?
And so my second question is at the department is going to determine. So if you get 10 applications that meet the requirements at a time, who determines out of those 10 who's going to get the 2 to 6 licenses that you can award?
That decision will rest with the commissioner of the Department of Public Health.
Okay, so it's not outlined in the bill how that would go. It's completely within discretion of the department.
That's correct. Based on the criteria, there is criteria put in the bill, but the ultimate decision will be with the commissioner. That's correct.
Mr. Tremmel.
Thank you, Mr. Chairman. Representative Peake, I'd like to focus on lines 636 through 643. As you made your presentation, the way I understood you to describe the bill was that a licensed manufacturer would be permitted to have up to 4 distribution facilities. The concern I have with the language, and maybe it's in another part of the bill, it seems to have a mandate. The language would seem to mandate that they actually operate 4 distributional facilities. So that's one concern. And then the second...
That is correct, and that was the way it was designed, so that there would be that geographic distribution for the dispensary.
So to the point you were just making about we can't anticipate what demand is, I guess the suggestion would be that having a mandate that the manufacturer open 4 distribution facilities could potentially implicate their profits, and we could have a situation where they really only need one, or there's only one that's profitable, and I worry that putting those regulations in place may set the system up to be economically infeasible.
And I can tell you from chatting with my colleagues in Minnesota, they have found that to be potentially problematic, and I'm willing to address that and massage that, however, in the wisdom the committee thinks is best.
Thank you, Mr. Chairman.
Mr. Peck.
Representative Peake, I'm focusing on line 783 on the employer section.
Okay.
I'm a little worried about kind of there's the language here says an employer can't reject an applicant solely based on the enrollment in the registry or testing positive for cannabis, right?
That's correct.
I'm afraid that's kind of first of all, we're an at-will state,
right,
and then now we're changing that. That's a dramatic change. And having seen kind of lawsuits, you're always going to have, when you have language like solely for, you're always going to have an allegation that was the reason, or on the defense side, they're going to say, well, that was not the only reason, right? I feel like adding this language really doesn't add anything new. And looking back at the language that I asked you about previously that you struck, it seems to me that those employers who are knowledgeable and accepting of this situation are going to allow that anyhow.
Right.
And I think this will do is it'll catch folks who are maybe not so comfortable with it, and we're kind of imposing an obligation on them. And I'm concerned about the language here on small businesses and employers. Would you be open to going back to the language we had last year in terms of kind of letting the state of the law as it is with respect to those who may be registered in the registry or test positive on cannabis metabolites?
I'll say it in a couple of ways. One, I'm open to whatever the wisdom of this committee is, and so and yes, I am open to go back to that language. I'm an employer myself. I have 1,200 employees, and the last thing I want is somebody come up in one of my restaurants saying, trying to use an excuse that they're on the registry card and they're high,
right,
and they're smoking marijuana, and so we try to provide, language in here that says they, you can't dismiss them or reject them unless they're impaired. Now, I know you as a lawyer can probably tell me I know that's a broad area. So, and this is a tough one, this one right here in particular. I don't want to create a new class either, which is what we potentially may be doing. So I get that. So to answer your question, yes, I'm willing to work with the business community, with the committee, to come up with a solution that works and makes the bill practical.
May I follow up, Mr. Chair?
Sure.
On lines 804 on 812, I see the intent you have there, and I think this might be just the wording of it. I think that it might be wise to have attending physicians having relationship with these dispensaries for several reasons. And I understand why you're trying to get it. You don't want them to, for the sake of just making money or whatnot, to prescribe. But, I could think of a scenario when a dispensary for quality control and keeping up with the latest kind of in the field experience, they might have advisory boards and things like that where a physician who's been prescribing dispensary might want to be on the board to advise them. And in that case, and in other cases where you have, the way you have the language here in line 806 says they can't have any financial interest in a medical cannabis manufacturer. And usually when you have conflict of interest rules like that, you have a either a materiality threshold, because you can imagine when, like for example, if the company in England that produces the pure form of cannabinoid oil is publicly traded, right? Yeah. And then you own some stock in that, and which I think a lot of people do invest in companies that have it. By your definition, it'll fall under medical cannabis manufacturer, because they could own the dispensary, in the States. And I thought maybe, I'm just merely suggesting that we may want to tinker with the language to allow some relationship, and that the financial interest may be something that's immaterial, that's okay, whatever that means. I think it's generally a certain dollar amount or whatnot. Because I think the pharmaceutical companies, what they generally do is they want to have advisory committees with practicing physicians, and they do have either a retention or some type of a reimbursement per diem type of thing for serving on boards. I just say that as a policy matter, and I understand what you're trying to get at, but it may be too restrictive that may hinder your cause in the future.
Yeah, it was out of an abundance of caution to make sure there wasn't appear to be any conflict. I do think we've got, and I'll ask Ms. Travis, she's my expert lawyer, that it's only financial interest in a medical cannabis manufacturer as defined. So it really would only be in the licensee. It wouldn't be in a GW Pharma who's traded publicly. So is that fair to say?
The language is pulled from the DUI, the DUI commission in a lot of people and stuff. So it was mirrored after that. That was the thought process of, how those are interactive.
Right.
And but I see your point.
And I'm willing to have some more discussion about that. The intent was just abundance of caution. Let's just make sure we don't appear in any way, shape, or form. But help me with language, and I'll be more than glad to take a look at that.
Mr. Coomer, last word.
Thank you, Mr. Chairman. I have a couple of different issues I wanted to ask about, but let me just start with where Representative Pack was leaving off, or where he started actually, back on 788 to 790. If you break down the sentence, what you get is an employer shall not terminate an employee based solely upon the employee testing positive for cannabis metabolites. That's the part that would be most concerning to me. I understand wanting to give people an opportunity to be on the registry without having the registry affiliation itself create a problem for them in employment or termination. But that seems to be inconsistent with what's been the policy of the state with, drug-free workplace incentives. And I know I know some manufacturers in my district who will hire people and they hire them and they're there for 4 or 5 days until their test results come back and they're positive for marijuana or whatever it is they've been using. And they terminate them immediately because they don't want to have people in the workplace who are using illicit substances of any kind, including marijuana. So,
and most of the time, to not violate the drug-free workplace requirement. I understand that. Yeah.
Right. So, would you be open to modifying that language so that we keep in the part about we keep in the protection related to being enrolled in the registry, but remove the protection for the testing positive?
I would, Chairman Cooper, and I'm
yes, I'm Chairman
sorry,
Coomer, not Chairman Cooper.
Sorry.
I have no, never mind.
Yeah, we won't go there. The answer is...
I'm taller, thank you.
The answer is, and nicer, the answer is yes. I mean, I'm willing to entertain that. We've actually had conversations Chairman Coomer, that that maybe we go into the drug-free workplace and make an exemption for medical cannabis as now defined in Georgia law. That maybe that would solve the problem. That you can continue to have a drug-free workplace environment, get the discount on the premiums and so forth, as long as you had an exception for medical cannabis in that law. Now, that's getting into a whole other code section, a lot of language, but that may be an option and may get to the heart of what you're getting. Is that
Yeah, I understand, and I don't have the solutions. I'm sitting here asking the question, so it's just a concern that I've heard raised by others, and it is a concern I share. That I would like you to see if there's a way to make that function in this bill.
And here's my promise: I'm committed to doing that. I'm an employer with 1,200 employees, and so I understand this issue as well as anybody, and I want to make sure it works too. So.
Mr. Chairman, may I ask a couple more?
Sure.
Okay. Going back to line 190 through 194, excuse me, and I apologize for my raspiness, but this provision says that it shall be lawful for an employer agent of a manufacturer to possess or have under control marijuana if, at the time of such possession or control, he or she has identification to verify such employment or agency relationship in his or her possession. My concern with that provision is that it may be incomplete because there's nothing in this provision to require that the possession be related to the employment or the agency. And so I wouldn't want to create a protected, I wouldn't want to create a special defense for people. And I think this is exactly what we're trying to avoid: is having people work work for these companies who have a little side business going on.
Sure.
So I think we would want to clean that up by tying some requirement that would show a requirement that the possession is in the scope of their status as an agent or employee.
I think, Ms. Travis, I think we addressed that, don't we, in another section?
No, that was the
same question that,
Representative Strickland.
Yeah. Hightower.
Hightower had asked. Yes, and no.
I'm sorry, I missed that part.
Okay.
There's some more work to be done.
Okay.
All right, yeah, that's
Okay.
a good point.
And if I'm asking something that's already been asked, just cut me off there, and that's fine. I'll move on. The other one is on the next page in line 230. Well, it's the part about buses. Line starts in line 212, and then we get down to line 234, which is the prohibitions of engaging in the use of medical cannabis, and it says on a bus or other transportation furnished by a school, and on the grounds of school, on child care learning facility. Is there any reason that we didn't include just public transportation in that list of places we'd prohibit use?
Well, I mean, it was the intent was to keep it away from kids on a school ground, and I mean, an adult traveling on public transportation, who might need to take it and take the product 3 times a day, going to the grocery store maybe shouldn't be prohibited from having access to it on a public transportation. So, I mean, that was the intent was let's just make sure we keep it away from kids and school grounds.
Okay. And if I may, I'll just ask this one more, if that's okay, Mr. Chairman. One more issue, and that's over on lines 328, and really throughout that section. The question I have is, well, let me set it up this way. The department in this section refers to the Department of Public Health.
Correct.
But the provisions of this section really have a lot to do with security, tracking, and then there are other sections that have the same kinds of issues addressed. Aren't there other agencies that may be better suited to that kind of work than Department of Public Health? And I heard you say earlier that you wanted to kind of streamline it, keep it all in one department. But couldn't we be better served by actually putting some of these responsibilities into the agencies that have routine experience and expertise in, like, security and monitoring? I'm thinking specifically Department of Public Safety or or other agencies that may be better suited to that.
I'm open-minded to that. I mean, again, the intent was to streamline it. There are vendors that provide this tracking software. There's an industry out there now across the country, and so I think the Department of Public Health would be required to provide a list of vendors for security and tracking. I think could be able to provide vendors that would provide the same services that maybe another agency would as well too. So, but I'm open-minded to having that discussion.
Okay, thank you very much.
Yep.
Mr. Peake, thank you. I appreciate your time and going through it. The committee will take we'll suspend for 3 minutes, a real 3 minutes, and then we'll come back and I'll ask Sheriff Wilson and Sheriff Silk. Is it Silk? Yes. Sisk, I'm sorry. That was an S. I apologize. Sheriff Sisk, just to be ready at the table if they could be. We'll be back in 3 minutes.
Thank you, Mr. Chairman, members of the committee. Appreciate it. Well, I told you that would be boring. Hey.
Catoosa County. I'm the sheriff there. I've been in law enforcement over 25 years. I haven't talked to or seen or met a drug addict that at some point in time hasn't stated that they started some of their usage off using marijuana, and it's only continued to develop further. We have a serious drug epidemic in the United States and here in the state of Georgia. We already have a number of guidelines that is used for prescription drugs and controlling that. However, we see that doctors and patients abuse that daily, and we deal with it every day on the street in our communities. And to only add something else to that issue is a grave concern. We will have to deal with this on the street, and some of the wording that is in the law is very difficult, as you brought up the questions here today, to swallow. And we feel in bringing any kind of manufacturing and cultivation of marijuana into the state of Georgia is only going to lead to serious issues with our communities, with bringing more challenges to our young people, and issues for our law enforcement. And we just don't think that that's going to be something that's beneficial to the 10 million people that live in the state of Georgia. I understand there's 545 people on the registry, and if those are young people, we would love to do what we can to help them. But we're talking about all the other tens of millions of people that are going to also be dealing with this issue. Over 53,000 law enforcement officers that are going to be dealing with this issue. I believe Sheriff Wilson has a few more points to make.
Thank you, Sheriff. One of the, and Representative Peake alluded to this, I think, during his presentation, or was questioned about it, is this bill is modeled after Minnesota's current operation, and I think it's been in place 6 or 8 months or so, something to that effect. In speaking with our counterpart in Minnesota, the executive director of the Minnesota Sheriff's Association, we have found that the growers there are struggling financially. And you may say, well, that's to be expected on any startup business, and that you're going to lose money in the first year or so. But they are losing money because of not having the quantified number of patients to serve there in Minnesota. And my question would be, where does that lead us down the road? And I know that that's looking into that crystal ball that we really don't have the answer, but I think we have to think what ifs with this particular bill. We have to all say, what if this bill passes? What are we going to be faced with in the coming years as this for-profit company struggles to make money with medical marijuana? Where is it going to lead to? And that is my fear, that it could lead further down the road to other sources of laws being passed. I know Representative Peake said that he is stopping here, and I take him at his word, and I know that he has a passion for this. But Representative Peake and myself and most of you gentlemen are not going to be here forever. There'll be other people coming behind us and following us in our steps. And once this bill, if this bill were to pass, what will it lead to in the future is what I think we all need to think about strongly.
Thank you, Sheriff Wilson and Sheriff Sisk. Questions for either Sheriff Wilson or Sheriff Sisk? Mr. Trammell.
Thank you, Mr. Chairman. Sheriff, thank you for being here. My question is about number 5 on your proposals, or your position statement. And assuming for the moment that the committee and the legislature was going to do something in terms of a regulatory scheme to provide for access to medical cannabis, what would the appropriate controls and security measures be that you would advocate for and want us to have in that legislation?
You're referring to the manufacturing facilities and the distribution facilities, I believe, would be what your specific question is.
Well, and if it's not, if there's a way to do it without going down that road, I'm just asking what are the safeguards that'll help you and put in place to protect and make sure that we don't go down the road you're talking about?
Well, first of all, I think the tracking of the marijuana from seed to growth to distribution is almost impossible to be able to do completely, and to control that and see everything going out the door. It was already brought up by another individual about possibly, I believe, you, Mr. Chairman, that you'd said something about possibly considering another agency besides public health being part of a security solution or something of that nature. And I definitely wouldn't disagree with that I don't think public health is anywhere to a point that they could look over security measures. And two, the bill brings in that the company, the manufacturer themselves, will be presenting their security measures to public health. So that's kind of like the cat guarding the chicken house or the hen house, as far as they're setting their own standards of saying, here's what our security measures are. So at this point in time, there's really, with the no way of being able to control what's actually going out the door completely, without maybe it being a state agency that does it and nonprofit, and then we know that's all it is, then that's about the only way.
I might add that the majority of our counties in the state are rural counties that lack very much funding on the local level, and I'm specifically talking about the sheriff's office in those counties. And I know that should the bill pass, that there would be located geographically across the state, and most of those would probably be in smaller counties where the sheriff, it may be just the sheriff and one or two or three deputies. I know that's hard to believe in 2016, but we have counties out there where resources are very limited. So putting all of the security back on the sheriff or the police chief or whoever it may be, I do believe and know it's unreasonable to ask that. So I would certainly, the security end of it, from as far as a facility management, would be something that's going to be very, very important as you look through this entire bill. And also, as Sheriff Sis said, tracking the substance from seed to plant to growth to harvest is another totally issue. But if we're talking about the plant itself security, then don't rely on public health or the sheriff of that county to be able to do it all.
I see no further questions. Sheriff?
Thank you all for your
Thank you
time.
very much for being here and for making the trip and for giving us your perspective, both personally and on behalf of your association. Members, we're going to go ahead and conclude. I will schedule another hearing, as per my comments earlier, as soon as possible and practical when I see the other business that's coming through the committee, and trying to just keep the wheels turning. That may be as soon as Friday morning. Wednesday, members, we're going to have a very long calendar of bills that have come through subcommittee and are ripe for full committee consideration. But on Friday, you should at least plan as of this minute that we would go ahead and meet between 10 and 12, and at least part of that would be dedicated to House Bill 722. And we'll just take it from there. Thank you, everyone, for being here.